Welcome to Case Flash, brought to you by the CBA Family Law Section. Today's program addresses appellate review of unpreserved claims, the adversarial system of justice, and the Supreme Court's decision in Blumberg Associates Worldwide. I'm Sam Schoonmaker, and with me today are Judge Elaine Gordon and Attorney Wes Wharton. The basic facts are convoluted and not particularly important to understanding the legal principles involved in this case. Rather than wade through them, the facts will stream alongside the video, and the speakers will introduce them as necessary during the discussion. Suffice to say that a mailing mix-up, allegedly caused by the defendants, resulted in the plaintiff failing to renew its insurance license. Thereafter, the plaintiff and the defendants entered into a new written contract. After that, the defendants terminated the contract on the basis the plaintiff had lost its insurance license. The plaintiff commenced a breach of contract action. The defendant moved for summary judgment. The trial court granted the motion. Plaintiff appealed and made a compelling argument that the trial court had misapplied the prevention doctrine when it granted summary judgment. After oral argument, the appellate court ordered supplemental briefing on an issue that had not been raised by trial counsel, appellate counsel, or the trial court. The plaintiff objected. The appellate court proceeded to affirm the trial court based on the unpreserved issue that it had raised sua motu. The Supreme Court granted certification, and then it affirmed. Judge Gordon, what is an unpreserved claim, and what generally happens to an unpreserved claim on appeal?
Well, an unpreserved claim is one that hasn't been noted or brought up, during the trial, meaning it's unpreserved, hasn't been raised. And normally what happens to it is it goes nowhere on appeal unless it falls into certain categories, which our case law has told us give rise to the ability perhaps for review of an unpreserved claim. And that's whether or not it raises an issue of subject matter jurisdiction, whether it raises a Golding issue, that is a constitutional issue, whether it raises an idea of plain error, or whether, as we'll find out in these cases a little bit more, whether it raises the supervisory powers issue of the court. But other than those exceptions, it doesn't really go anywhere.
Attorney Horton, this case addresses all those various exceptions to the general rule. What does the Supreme Court decide in Blumberg Associates Worldwide, and what's the basis for its decision?
It's decided two major things. Number one is that the appellate court can consider an issue not raised by the parties, by and large in the same situations in which a party could raise an issue on appeal that they didn't properly preserve in the trial court. The second thing they've done is to say, to decide when it is that either the appellate court or the parties can raise these unpreserved issues on appeal. They've put it into basically three areas: one, the Golding rule; two, the plain error rule; and three, the supervisory powers rule. The first two were pretty well documented as to what they cover. What they've done in Blumberg is they have put in one place all the various categories that qualify for supervisory powers, where you've had to go to individual cases to find each possible way. Now they've tried to gather them all together, so you only need to go to Blumberg Associates to find it out. Now there are certain things that the appellate court, that apply if the appellate court is raising something suo motu, that don't apply if the parties are raising it. The first thing is, and it's a rather obvious one, if the appellate court is going to raise the issue suo motu, in other words, on its own, it has to give the parties a chance to brief the issue on appeal before they decide it. And the second thing is, unlike certain areas of unpreserved review, for example, plain error and the Golding rule, if the lawyers raise it and it's properly raised as a Golding rule issue or a plain error issue, the appellate court has to decide it. Whereas a Golding issue or a plain error issue that the appellate court wants to raise on its own, it doesn't have to. It's within its discretion whether to raise the issue.
So can I interrupt? So there's still meaning to the Golding review. It
Yes.
hasn't just simply been subsumed by this decision.
That's right, exactly. In other words, if it's a Golding review has to do with unpreserved constitutional questions. if a lawyer raises a Golding issue on appeal and he meets the 4 prongs for review, the appellate court has to review it. They have no discretion not to do so. The only difference in Blumberg Associates brings out is, number one, if the appellate court doesn't have to bring up Golding on its own unless it wants to. And number two, they're cataloging all the areas that would apply as a matter of discretion under the supervisory powers that don't apply under Golding Review. So Golding Review is still a very live issue and should be raised wherever it applies. It's the same for plain error. If there's been a miscarriage of justice, the lawyers should raise it as a miscarriage of justice, not as supervisory powers, because if it's a miscarriage of justice, the court has to review it. Supervisory powers never are mandatory.
All right. So this case, the supervisory powers are for exceptional circumstances. Is that right? So what kind of circumstances are exceptional? And what was so exceptional about this case? This is a contract case.
Well, it's very interesting. There didn't seem to be anything, I think you said it best. The facts are not particularly interesting. There didn't seem to be anything particularly exceptional. And I think that this is a very difficult case to read, and I'm going to give this to Attorney Horton in just a second, and I'm going to plug the fact that he has done a roadmap, a decision tree through this case that's going to be published in the Connecticut Lawyer, and I urge everybody to take a look and read it. And there's going to be an article in there as well. But I think that he can best answer that by maybe taking us through the tree.
Right. So taking us through the tree, are you going to convince us that this really is nothing new?
Yes, I am going to convince you this. Let me show you my handy-dandy chart, my 32 question chart that you probably can't see, but I will say this about Blumberg Associates. Justice Palmer, for a unanimous court, does a valiant job of trying to put all the permutations of unpreserved review in one place, which is a difficult thing to do in writing in paragraph form, because you're jumping back and forth, and it gives you a headache, basically, to try to figure out all the permutations. It's an ideal situation to have a decision tree. I did it initially just so that I could figure out what the decision was actually saying. And when I got through the decision tree, it came to me, when I first read Blumberg Associates, I thought, wow, this is the court is going off in a wholly new direction. They're really opening up the use of supervisory powers. There's going to be lots more unpreserved review. There's going to be lots more suo motu review by appellate courts. And after doing the decision tree, I concluded exactly the opposite, that all they're really doing is putting what they've said before in one place. And when you go through my chart in detail, you will see that while it looks intimidating, it actually, if you just follow it, there are many points where you stop here because it's unreviewable. And at many points, all it's doing is just saying, does this category apply? And if not, skip down 2 or 3 more categories until you get to the next one. So it's the questions I ask are very simple ones, and when you do it in this format, I think you'll see that it's a comprehensive decision that's difficult to read, and you do have to have a decision tree. And when you have it, you see what you first decide is this something that the appellate court wants to decide on its own? And the first thing the court has to decide is the record adequate to decide the issue? And if the record is not adequate, it's not reviewable. You just stop right there. That's why I say my chart is not so intimidating as it looks, because if you get there, you don't need to go any further. But assuming the record is adequate to decide the issue, then you go through the Golding analysis, and if that doesn't apply, then you go through the plain error analysis, and if that doesn't apply, then you go to the supervisory powers. And here's where they put everything in one place. And the first thing, and I think Justice Palmer is doing everybody a favor by putting these things on the table that you don't think about expressly. Because the first thing he says you want to do is, before we look at an unpreserved issue, or even think about looking at an unpreserved issue, can the opposing party make a colorable claim of prejudice that I would have done something differently if I had known this issue was coming up in the trial court? And that's a very valuable thing to say. And what he says is, for the answer to that is yes, then the burden of proof shifts to the other side to show that's a lot of nonsense. He's just making that up after the fact. The fact is that there's no prejudice to the other side. So if it turns out that there's no prejudice to the other side, then it's relatively easy going if they want to use their supervisory powers. Basically, the situation there is the issue well briefed? Is it too complicated for us to spend our time on? Is this an issue that we want to reach, basically, is what you're saying. And in that situation, if there's no prejudice to the other side, in most situations, they can use their supervisory powers if they want to. And they can especially use it in a case, and that applies here in this case, is the issue, even if the opposing party objects to review, if the opposing party is going to win anyway, then why not get to the issue? And that's, in fact, exactly what happened in the Blumberg Associates case, because I agree with Judge Gordon that it looks like a relatively uninteresting issue, and yet the judgment was affirmed anyway. So even though they got to the issue, the person that would not want it to be considered was going to lose anyway. But
Can I ask you,
go ahead.
are you finished with your chart?
Just one more thing on the chart, and that is, assume for the sake of argument that there is prejudice to the other side, then it's extremely unlikely that the appellate court is going to look at the issue, which is the same as it's been all along, that they really do have to be extraordinary circumstances, which undoubtedly would have applied in the Blumberg case. And then you've got to show it's something like judicial bias, or it's there's been an intervening change of the law, or it's something of a great public character that they just have to decide it in the public interest. Things that they have traditionally said under the supervisory powers they will do. But if you can't come under that category, then I've said at the end of my chart, if you reach the end of the decision tree and the answer is no, it's time to give up.
Judge Gordon, this is an adversarial legal system that we have, where parties raise issues and then the judges decide those issues. Are we still in an adversarial legal system after this decision?
Well, I think we're still in an adversarial legal system. At first reading, as Attorney Horton said, it felt like going, whoa, we're going off in a whole new direction. Now, if you look at the decision tree broken down, it may not appear that it looks like this is still going to be exceptional, and we still have our adversarial system. I'm a little bit concerned because adequacy of the record is kind of in the eye of the beholder, so and to some degree, and prejudice may be. So I still think we have a lot of wiggle room. You're always concerned whether who owns the case and whether the parties own it or whether the court owns it. So I'm hoping that this isn't a new idea of this, kind of lurking on every case, because I think that would be damaging to our adversarial system, but I don't see that quite yet.
Yeah, I think the opinion tries to make clear that this is still an adversarial system. We're not moving to a inquisitorial European system. We're still an adversarial system, but there is this exception for exceptional circumstances. Right. To me, the difficulty is deciding when it's an exceptional circumstance, and now we have a system in which the appellate court, an intermediate appellate court, can raise an issue sua moto, and that decision will then be reviewed by the Supreme Court under the abuse of discretion standard rather than de novo.
Yes.
What do you see that as an issue at all, or that's just that's appropriate.
I think it's going to be hard if the appellate court says we don't want to use our supervisory powers for the Supreme Court to say that's an abuse of discretion. I think it is possible, on the contrary, though, that if they exercise their supervisory powers in a case where there is established a prejudice to the other side, I think they could be going too far. So I think they should be careful on that.
So that's where the abuse of discretion review might come in, and is more on prejudice
Sure.
than on maybe other issues. It's on the prejudice. So if you're an attorney on the other side, and the appellate court sua moto raises a new issue, an unpreserved issue in your case, and asks for a supplemental brief, what do? Do you object? And then you brief it, and then you assert that how you've been prejudiced specifically, and then you just hope for the best?
Yes. In fact, if there's one thing that I think this case makes lawyers go back to the drawing board and think about doing things differently, it's thinking about the colorable claim of prejudice and the burden of proof shifting to the other side to establish lack of prejudice. That is new. I mean, it's not necessarily new, but they've never said what you do about the prejudice issue, and now they've explained exactly how it works. This affects both the appellate lawyer and the trial lawyer. For the appellate lawyer, you've got to be thinking about how you make a colorable claim of prejudice. And for a trial lawyer, you need to be thinking about, oops, the other side hasn't brought up this subject. Do I keep my mouth shut, or do I start trying to put some prejudice in the file so that my appellate lawyer is going to be able to show what the prejudice is when the appeal comes up?
Looking at this from the perspective of a former trial judge, this decision was also dealt with the alternative basis for affirmation. What's your view as a former trial judge of the use of the alternative grounds to affirm as was done in this case?
Well, I always kind of like the idea that you can get the result that's right, maybe for not quite the right reason, and still have that win in your column. That's good. But I think that more important for trial judges and stuff, you want litigants. I do believe that litigants own their cases, and you want justice to be done. So as long as we're doing this, I think that we should keep that in mind, and I would urge trial judges, when things are coming up, there's always a little bit of resistance when the appellate court raises something that you didn't have an opportunity to address, and you're worried about whether you're going to be reversed on a ground that you didn't get a chance to deal with. You get a little annoyed, but I think that if you think of it in terms of the fairness and justice for the litigant, and this procedure provides for that at many different steps, then you should just think, it's good that I have a safety net, and think of the appellate court as your safety net, and that it's an opportunity for things to go right for the litigant, and it's not of really no harm to you.
Attorney Horton, is this an important decision?
Yes, it's an important decision, not so much because it plows new legal ground, but because it puts everything in one place. If you want to learn about when you raise an unpreserved issue and when an appellate court reaches an unpreserved issue on its own, Blumberg has it all right there. It's difficult to read. It gives you a headache as you're trying to do it. And if you get a headache doing it, my suggestion is use my chart. It may give you a headache too, but maybe less of a headache.
And I agree that this does put everything in one place. I think the question is, how will this be applied? How will this decision be applied by the appellate court? How significant will it be in practice? And I think that's an unknown. Thank you for watching Case Flash.